a guide to handling deprived juvenile cases in Okmulgee. Few legal proceedings are more serious than a juvenile deprived case. When the state of Oklahoma alleges that a child has been abused, neglected, or placed in unsafe circumstances, the court may open a deprived action that can ultimately affect custody, visitation, and even parental rights. For parents in Okmulgee County, these cases often move quickly, and the decisions made during the early stages of the case can have long-lasting consequences. A deprived proceeding is not a criminal case, although criminal allegations sometimes arise from the same events. Instead, the purpose of the case is to determine whether a child needs court protection and what actions are necessary to ensure the child's safety and well-being. Deprived cases often begin with emergency removal. Many deprived cases begin when DHS or law enforcement believes a child faces an immediate risk of harm. In those situations, the child may be taken into emergency custody before the court has heard all of the evidence. Oklahoma law generally requires an emergency custody hearing within 2 judicial days after the child is removed, so the court can determine whether emergency custody should continue. The emergency custody hearing is one of the most important stages of the case. Parents have the right to appear, present information, and seek the child's return. The court may order the child returned home, impose conditions on the parents, or continue DHS custody while the case proceeds. You have important rights as a parent. Many parents feel overwhelmed when they first enter juvenile court. However, Oklahoma law provides important protections. Parents generally have the right to receive notice of the allegations, to attend hearings, to present evidence, to testify on their own behalf, and to be represented by an attorney. Parents who cannot afford counsel may qualify for court-appointed representation. Because statements made in juvenile court can sometimes affect related criminal investigations, it is often critical to obtain legal advice before making significant admissions or agreements. The state must prove the child is deprived. The filing of a petition does not automatically mean the allegations are true. Eventually, the court must conduct an adjudication hearing to determine whether the child meets the legal definition of a deprived child. The state bears the burden of proving the allegations contained in the petition. Evidence may include testimony from DHS workers, law enforcement officers, medical professionals, teachers, counselors, relatives, or other witnesses. Medical records, photographs, school records, and other documentation are often introduced as evidence. If the court finds the allegations proven, the child may be adjudicated deprived, and the case moves into the dispositional stage. Compliance with court orders is critical. One of the most important things parents can do in a deprived case is comply with the court's requirements. Courts often order services designed to address the concerns that led to the case. Depending on the circumstances, a parent may be required to complete counseling or parenting classes, undergo substance abuse treatment, submit to drug testing, obtain stable housing, maintain employment, participate in visitation, and cooperate with DHS. Parents who actively engage in services and demonstrate progress often place themselves in a stronger position to pursue reunification with their children. Attend every hearing and visit. Judges closely monitor a parent's participation throughout the case. Missing hearings, ignoring court orders, or failing to attend scheduled visits with a child can significantly damage a parent's position. Many parents do not realize that the court reviews not only whether they completed services, but also whether they consistently demonstrated a commitment to reunification. Regular visitation and meaningful participation in the child's life often become important factors as the case progresses. Oklahoma law generally recognizes visitation rights unless the court determines visitation would be harmful to the child. The goal is often reunification. In many deprived juvenile cases, the court's initial goal is to safely reunify the family. DHS may provide services to help parents address the issues that led to removal and work toward bringing the child home. Oklahoma law even provides procedures for trial reunification periods when appropriate. However, reunification is not automatic. The court will continue reviewing whether the child's health, safety, and welfare can be protected if the child is returned home. permanency planning becomes increasingly important. As a deprived case continues, the court will focus on achieving a permanent and stable placement for the child. Oklahoma courts are required to adopt permanency plans for children who remain in out-of-home care. If parents make substantial progress, reunification may remain the permanency goal. If progress is not made, the court may consider other alternatives, including guardianship, placement with relatives, or termination of parental rights in the most serious cases. Because the stakes increase as the case progresses, early action is often essential. Termination of parental rights is the most serious outcome. The most severe consequence in a deprived case is the termination of parental rights. If parental rights are terminated, the legal parent-child relationship is permanently severed. Oklahoma law recognizes the importance of legal representation and procedural protections in termination proceedings because of the serious rights involved. Fortunately, not every deprived juvenile case results in termination. Many cases are resolved through successful compliance with court orders and reunification efforts. Okmulgee family lawyers. Juvenile deprived proceedings move quickly and involve complicated statutes, court rules, DHS policies, and constitutional rights. Parents who attempt to navigate the process without experienced legal counsel often find themselves at a significant disadvantage. Because deprived proceedings can affect your relationship with your child for the rest of your life, obtaining experienced legal representation as early as possible is one of the most important decisions you can make. For a free and confidential consultation with one of the family law attorneys at Okmulgee Lawyers, call us at 918-621-8083. To learn about other legal topics, check out our Okmulgee Law blog.